long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a political scientist at Northern Kentucky University. On Friday, September 20th, Jay and I recorded a live show at a Federal Bar Association conference in Cleveland, Ohio. It was a great event, and we loved having the opportunity to debate some issues face-to-face and before a room full of people. We were able to record it, though the room acoustics weren't ideal for that purpose. We hope you enjoy our discussion, which, given our audience, was focused on judicial issues. Finally, if you'd be interested in having us come to wherever you are to do a live show for your business, school, or organization, let us know. You can reach us at mail@politicsguys.com.
Well, thank you very much for having us. We are the Politics Guys, and this is as far as we know, first of a kind live podcast at a Federal Bar Association event. So bear with us.
Yeah, as the liberal, I'm the guy with all the big ideas for changing things, and Jay's the one who generally is saying why this is such a horrible idea. And so I thought we'd start with me talking about one of my many great ideas for reforming the judiciary. In this case, the judicial selection process and confirmation process. And I'll start. I don't want to give Jay kind of whiplash or shock him too much. So I'll maybe start with something a little bit easy. Maybe even something, every once in a while he agrees with me. So we'll see, I don't know. But, in light of what happened with Mitch McConnell making up some interesting rule precedents so that he wouldn't have to confirm Barack Obama Supreme Court Justice, one of the things I suggested to Jay is I'd really like to see something this would either be in Senate procedure or would be potentially even a constitutional amendment saying that the Senate would have to give an up or down vote to any Supreme Court nominee within a period of 6 months. And Jay, I don't know how you feel about that. Now, obviously, that's not what happened when it was a Democrat that Mitch McConnell had that option to do that with. But when it's a Republican, as you know, it's been a record pace of just pushing it through fast and furious. So what do you think about that?
Making hay while the sun shines.
Yeah, absolutely. Yeah.
No, I think we would start with I always start with Federal 78 anytime we're talking about the judicial, and this is particularly important because I think that if you are any kind, it's if you go back and read, like you should get up and read Federal 78 every morning. If you're in the legal world, Hamilton very much saw the judicial branch as the weakest branch inherently. Right? They didn't have the power of the sword of the executive. They didn't have the power of the purse. So he was very big on the idea of lifetime appointments. But at the same time, I think also recognized the difficulty of if you have a up-down, your requirement to have a vote within 6 months, that does, I would say, impede on the constitutional prerogative of the Senate, which is to the words I'm looking for, I've stumbled over them.
Well, whatever the word is, yes. I don't think it impedes on it. I mean, if you take a look at the history of judicial confirmations, at least to the Supreme Court, the longest period ever between a presidential nomination and a result, whether it's a confirmation, a judge being rejected, or that judge withdrawing, was 125 days. And that was Justice Brandeis under the Wilson administration, I believe. So 6 months is not at all unreasonable. And to me, advised and consent doesn't mean, well, sit on it and just hope it goes away. No, advised and consent means the Senate needs to come back with some sort of a decision. And I think, frankly, that for all of his, Mitch McConnell would say he's a great defender of the Constitution and tradition. I don't think that's true at all. I think he's a great defender of getting as many Republican judges in there as possible by any means necessary. And so to me, that flies. I don't care if Mitch McConnell has Federal 78 memorized. That's not what's driving him. To me, that's not certainly even what's driving the modern Republican Party and most of the Democrats, frankly.
So, Michael, would you agree with me though in terms of how you would want to accomplish something like that? Is there a way to do this without a constitutional amendment? Because I think I keep coming back to that the Senate has that advisory role and approval role, confirming role, and to add an additional layer that would seem to take more than just Senate rules or even legislation.
Well, you could do it in Senate rules. Of course, the Senate changed their rules. But to me, the deeper problem, you have a lot more reverence for the Constitution than I do, which is, I'm not wadding it up and throwing it away or anything. But I'm not saying that the framers weren't brilliant guys, but they were working in a very different context, an 18th century context with a very different Senate that was chosen in a very different way. And so for me to think that these institutions, these processes set up in the 18th century, that they somehow are magically going to be perfectly fit for the 21st century is, I think, just it's sort of foolish to think that that's even possible. The system was designed with the idea of change, and now it seems like whenever someone suggests that, it's, gasp, clutch your pearls, we can't change the Constitution, which to me is just,
Well, I mean, I'm not saying you can't change the Constitution, but as a practical matter,
sure,
it would be extremely difficult to change it, especially on something like that would be controversial. But what would your thought be if what happens if the Senate simply chooses not to? Say they pass the rule, or there is legislation that says you have to vote a nominee up or down within 6 months, and they don't. What's the penalty? Who enforces it?
Well, yeah, I mean,
that's where I think we get to the constitutional crisis. Crisis, but the constitutional issue. So that I think is where I think you would need to have something actual amendment. I just don't see that happening.
So, but you don't think that when Garland was nominated, that we didn't, in effect, have a situation where the Senate just ignored its duty, its advise and consent duty? That what McConnell did was pretty much okay.
Well, I'm not. Well, if you're asking me to comment on whether I agree with what he did or whether he was, and this is where we get into these things, or whether he was within his authority to do that. I would say yes, he certainly has an authority to do that. And you and I both talked as this went forward. I sort of went on the record that I thought the better way to run a railroad is to have hearings and have up or down votes. But that said, I don't think there is.
Well, let me ask you this then. What does advise and consent mean then? Is it just like some three pretty words? They're not all that pretty, but they're three words. Or do they have any meaning then? I mean, it's an obligation on the Senate. As you point out, there's nothing. It's not like they get yanked out or anything. They're so is it pointless? Is this just a pointless part of the Constitution?
No, not at all. I would say that the way that advise and consent worked in that case was they took an advisement and they did not consent. I mean,
they didn't do anything. They didn't consent or not consent.
Well, but that's again, as a body, they did not. So I think that satisfied their constitutional obligation.
Oh, I think you're totally right.
So
yeah.
But what other? And again, because you are the academic, you've got the liberty to kind of come up with ideas that people like me might just call nuts. So there are other proposals that are out there as far as changing the judiciary that might lower the temperature of.
Well, maybe not nuts, but obviously something that's happened in recent years is we've seen the end of the filibuster for judicial nominees. First in 2013 with non-Supreme Court nominees, and then in 2017 when the opportunity came up to do that. Of course, it was the same Republicans who were saying this is awful and the end of the world. When the Democrats did it in 2013, suddenly a seat on the high court opens up, and hey, they did it, so I guess that's a reasonable principle. They did it first. Is now what we're operating based on. But anyway, it seems to me that I kind of miss the days of the judicial filibuster. In fact, I would even go further than that. What I would like to see is sort of you might even call it kind of a super filibuster for Supreme Court nominees, at least, and maybe appellate court judges as well, that would require maybe even as much as a 2/3 majority. Because what I see now are a lot more polarization in the nominations as well as on the courts. And I think that a requirement, and yes, this would have to be another constitutional amendment, would be that if you had to have 2/3 of the Senate agree on a nominee, that would automatically have a seriously moderating force, because there are a lot of these folks that just no way they could get 2/3. And it's not like 2/3 is a crazy number. You look back, what Scalia got, 80-something votes or something like that.
I think that's a point that we should make. Yeah. And a lot of times when we talk about what we agree on, what we don't agree on, is if you look at the way the judicial process, nomination process, the voting of it changed within the last 30 years, in the sort of the post-Bork era, and even the early Bork era, that there used to be a much larger consensus, but the stakes seem to have gotten higher. And I guess I'd first seek your, why do you think that is? And then second, how does this proposal lower those stakes?
I think under Reagan, conservatives started to realize that they had an opportunity to remake the courts, and they went and did that. And certainly Robert Bork was no wimpy centrist. This is a guy who had some pretty strong opinions and had made the mistake, I guess you'd say, if you were a conservative, and I was at that point, I certainly was, and who came right out and said what he thought. And my God, you can't have that now. And so nobody does that anymore. But we know who these folks are, and obviously groups like Heritage and the Federalist Society are hugely important, and they become a major player in this that they weren't 30, 40 years ago. And so what I think we've seen is a radicalization of the judiciary, and I think that's been started by the right, and so we're just seeing the kind of the left playing catch up on this.
Well, again, I disagree with that. But I guess the second question is, if that is the case, if the stakes are higher, and your next proposal would be essentially a constitutional filibuster, right? For
I'd settle for a regular filibuster, honestly. You know, I mean, I'll take what I can get. But and not only that, it's not just the filibuster. It's the blue slip process has basically been ended for circuit court judges, and that happened again. This was a Republican thing. If you take a look at the history of blue slips, we should
probably explain. I think most of our live audience probably knows what blue slips are, but the regular
go right ahead. Yeah, please do.
That it was the tradition that any senator from a state in which a judge was nominated could put in what was called a blue slip, essentially sort of being their veto of that senator from their state. Now, the history on that, Mike, is interesting because it goes back to a time when everyone really knew each other pretty well, and if you were the senator from the state, you likely knew all of the judges in your state very well, and if someone were a nominee and you had some sort of inside information, typically about bad character in those days, that's what would be the reason for a blue slip, as opposed to things that are now more ideological blue slips. But I'd agree with you. I think that's...
Well, I think the history is interesting because in the early 2000s, when the Republicans had the majority in the Senate, Bill Frist, who was majority leader at the time, decided, you know what, we don't really need the blue slip process. And then in 2008, Harry Reid becomes, I believe, the majority leader, and then we have blue slips. And then now in 2018, Mitch McConnell says, you know what, this is really kind of getting in the way a little bit, at least. So we can't have that, and so we're going to remove it again. So again, it strikes me as sort of deeply ironic that supposedly what used to be the party of tradition, and this is in part why I'm, one of the many reasons I'm no longer a Republican, because I feel the party has drifted significantly from its roots, has basically become the party of radical right political expediency, and so we'll do what we can to put as many of these judges in, and if a couple of traditions have to go by the boards, you know what, that's fine, because honestly, people don't even know what a blue slip is, and they're not even going to care.
You're not including me in that.
No, you care. Yeah, you care deeply. I know. But no, and so I think that's, and getting to that, I mean, if you take a look at the record, Mitch McConnell has been incredibly successful. Right now, I just looked this morning, 24% of all appellate court judges are now Donald Trump appointees. That's an amazing record in 3 years. Nobody going back 2 generations is even close to that number. I mean, Reagan was, I think, second at like 14% at this point in his term. And so, hey, the strategy of just saying, let's do whatever it takes has worked. And if for folks who voted for Donald Trump to remake the judiciary, that's been a big win for them. So, and if that's what you care about, and if that's what matters, and you don't mind trampling on tradition, well, Good for you.
I'll tramp on tradition a little bit. And push
like
back.
Mitch.
Yeah, no, but pushing back though, a lot of those appointments, some of it is a demographic issue. It's a number of the appointments that happened to have come open during that time. Now, you would argue, I imagine, that it's because other appointments could have been made earlier but were held back or pent up because of foot dragging by the nefarious Mitch McConnell. But that aside, I mean, from a more fundamental democracy question, I mean, wouldn't you agree that, listen, this is the president, and here's a vacancy, he's got the right to fill it with who he sees fit, and I guess how would you address that if we want to get more to less ideologically more merit selection?
I think I'd make a distinction, and this is something that Jay and I have talked about a lot in the past, and my general feeling on presidential appointments is the president does get to choose. It should be, unless the person is incredibly unqualified, for at least executive branch appointments that aren't the court. Because the court's special. These are lifetime appointments. These are people who are going to be in their jobs for 30, 40 years, even more. Certainly, that's why a lot of people in 2016 held their noses and voted for Trump, because they knew that there'd be this opportunity to remake the courts, and that's why I think judicial appointments have to be treated differently, and that's why I think the Senate has a special role in this, and I think that they're not taking that role seriously. They're just trying to jam through as many of their people as possible, and I think that makes a mockery of the tradition in the process.
So one more point before we move off of reforming the judicial process.
Or the appointment process, yeah.
And that is, you and I have talked about this. We've got another idea that it's not just yours, but others, regarding how many justices a president will get to appoint and whether it be automatic appointment. And we should note, obviously, the Supreme Court there's no constitutional rule that it be set at 9. That is statutory. That said, it's been that way since 1866. Mm-hmm. I take it back. In 1863, there were 10, which was weird. It was a weird year. But 9 in 1866, and ever since then. The last time this was tried to make a change to that would have been during the Roosevelt administration, 1937, the Judicial Procedure Reform Bill, which was
help the old guys do their job kind of thing.
Which I just wanted to note. This is as you criticize Senator McConnell back in those days when FDR was trying to get more judges through. Senate Judiciary Committee Chairman Henry Ashurst said that the motto of the committee, and he was a Democrat like FDR, was no haste, no hurry, no waste, no worry.
Ooh, very nice.
So I wish we could get back
rhymey,
to those, back to rhyming mottos for judiciary committees.
Yeah.
But I guess there have been some folks. Jonathan Turley, for one, has suggested the court ought to be 19 members. That seems to be a good number. Others have suggested as big as 27. Wow. And I know you have a proposal that's sort of like a hybrid of that we've talked about before. You're actually writing a book about it. And I was writing.
At least a chapter.
Right,
Yeah, exactly.
I was on the book with you, and then you fired me from the book.
Basically,
just like you traded Mark for the guy across the hall. But, yeah.
Well, basically, the bare bones of my proposal is that essentially every president would get at least one Supreme Court pick per term, and this would be made right after the midterm election, so not after the January where the president comes into office, though that president wouldn't get a pick if he or she has made a pick for the Supreme Court within the previous 12 months. And so I think this would do a number of good things. Number one, it would ensure sort of regular, not so much rotation, because the size of the court would grow certainly over time, though probably not all that much, really. It certainly wouldn't be, 19 or something like that, one of those things, probably not. But also it would mean that we wouldn't have these situations of just kind of waiting for someone to die or hoping someone retires. And so you would know that whenever you voted in a president, that president would get at least one Supreme Court pick per term. And I think that the two big things, it would, number one, it would lower the stakes in a way, and number two, it would ensure more of that kind of, more of that turnover and relevance and that sort of thing. And I think those are two very good goals, and I don't really see a big downside, but I know you do more than I do.
I do see some downsides, although I want to say that I agree with the idea that part of the problem that we see with Supreme Court appointments, particularly the Merrick Garland issue, was that there's a certain randomness to it that just seems unfair and just seems wrong. Is this any way to run a republic, that this justice and the fate of the law may change because Justice Scalia happened to pass away 8-9 months at a different time? The same might be said when people take retirement. But it's one of these, and there also are differences in when the Constitution was written about people's life expectancies and how long they would live, and there was actually sort of the idea of you'd probably be replacing people more often because of that than you are these days.
And I should point out that actually that argument was an argument that not just you made, but at that point he was just plain old attorney John Roberts early on in his career, who made a similar argument, in fact argued for judicial term limits, talking about the value of turnover and justices getting out of touch and so forth. I have a funny feeling that if you ask Chief Justice John Roberts, he might have said that his feelings on this his position has evolved or matured or something like that, but I'm a little more of a fan of the Reagan administration attorney John Roberts, who maybe was a little more open to these sort of things. But I shouldn't put words in John Roberts' mouth.
Sure.
I don't know.
No, well, and I guess the issues that I would see with your plan would be really the administrative ones, as the court would continue to grow and you would have this weird shifting number of judges, and it would lend some uncertainty to the law that I think would also sort of undermine that legitimacy that we're trying to get, right? We're trying to get rid of the sense that there is a randomness, because less randomness needs more legitimacy. But at the same time, the idea that each president gets a Supreme Court pick, one, it's not in the Constitution. It would seem to empower the executive more than what the founders intended. And second, again, it adds to that sort of fluctuating. You still have the same problem, right? The numbers are different, but you still have the problem of who's dropping off, either figuratively in retirement or literally. So
right. Yeah, I think you see a lot more value in the stability, and I see a lot more value of the kind of relevance and you might call it the fairness issue. I don't know, but that's not surprising given where we are in the political spectrum with that.
So, all right, well, moving on. The other topic we're going to talk about on today's show, and again, this is our special live from the Federal Bar Association, Northern District in Cleveland, Ohio, is administrative law. And it's been a big year administrative law-wise, and not simply, but because Judge Gorsuch, this is perhaps one of his biggest issues, and we had a couple of big cases come down. So I don't know if you want me to lead off or you to lead off on our
you're probably better at the whole facts of the case thing than I am, so I just guess. But
I think we'll start with this audience is generally has the understanding of what the Administrative Procedures Act is, how it works, and that is that agencies can make their own rules, and subject to a certain procedure. There's a public comment period. They have to be approved eventually. But there is some delegation of congressional authority, and it's permissible under the APA. But there's been growing skepticism, particularly from Gorsuch, that when courts look at either rules or how administrative agencies interpret statutes, the law has what's called, there are two doctrines. One, the Chevron doctrine from the Chevron case back in 1974, which says that agencies can have broad latitude. A lot of deference, courts will give deference when they're interpreting statutes relating to their expertise. And then there's sort of the redheaded stepchild of that, which is our deference, which came out of the our versus deferring. I'm sorry, our versus, who was the other guy?
That other guy, I always forget his name, you know.
I'm trying to think who else.
Him.
But the hour deference, there's a difference in that it relates to an agency interpreting its own rules. And was a big hour deference case that came before the court this year was Kaiser versus Wilkie, which involved a veteran who was seeking benefits for PTSD. He had been turned down by the Veterans Administration a number of times based on their eligibility rules. He sued. And interestingly, there was a split in here where the court, particularly Justice Kagan, who wrote the opinion, upheld our deference but cut it back some. So, I mean, if you want to talk about sort of your, I guess, the view from the left on where we fall on judicial deference to administrative decisions, because this is something we often agree on a lot of times. Even though it's a right-left thing.
We actually do a lot. And there's one case in particular, actually, that's coming up in the court's next term. It's Department of Homeland Security versus Regents of the University of California, and it's the case on DACA, where the Trump administration decided, well, you know, DACA is actually unconstitutional, so we're just going to stop it without going through the Administrative Procedures Act because we don't need to, because we don't feel that was legally done in the first place. And also, by the way, courts, you're not allowed to even rule on this, essentially. And this hits on, I think, three main issues that we talk about a lot on the podcast, which why it kind of amazes me that we actually have an audience, but when we're talking about administrative law type issues, you know, but executive overreach, which is something Jay and I tend to agree on a lot. Number two,
we're against it.
Yeah, we're against it. Number two, excessive congressional delegation of power. We believe that the non-delegation doctrine should actually mean something, in which case, generally speaking, we don't think it does anymore. And third, and this really sticks in my craw, and Jay, you too, I know, people deciding on the constitutionality of something based on whether they like it or not. You know, I like this, it must be constitutionally okay, or I don't like this, and it's obviously unconstitutional. I really think this case kind of hits on all of these things, because I'm a big fan of DACA as a policy. I think it would be a great thing if it were passed by Congress, but from the beginning, I said to Jay, you know, I think the Obama administration overreached in doing this, and just because I think it's a good idea doesn't mean I think it's constitutionally permissible for the executive to just go ahead and have this kind of discretion. And so I find myself in a weird position here. I'm totally against the Trump administration stopping DACA, but damn it, I agree with their rationale, which frustrates the heck out of me. But it seems to me that, yeah, it's kind of presumptively unconstitutional what the Obama administration did. And it's totally reasonable for the Attorney General to say, hey, we have reasonable grounds to say this is not okay and to stop doing it. And so while I'm not crazy about that result, I kind of forced into it by my understanding of what the law and the separation of powers entails. In this case.
I think we should point out, I mean, those regulations, but that's sort of one of the keys of what we try to do on this show, is that there are times when the result we get, we understand that it is not necessarily intellectually consistent with our positions, and I think that's important, and that's the sort of thing that I think you and I both try to highlight. Is that you can agree with a policy, but not necessarily, or disagree with policy, but not agree how you get there, and that sort of goes to a lot of these deference questions.
But you know, Jay, and the thing with this, it bugs me in two ways, because either way, what the Obama administration did isn't okay, because either they overstepped, in which case it's the executive exceeding its authority, or if that's actually authorized under the Immigration and Naturalization Act, well, then that violates the non-delegation doctrine. So I can't see any way that this policy result that I love is okay. And I've tried, believe me, I've tried, but as far as I can tell, it's just not there, and that's a real bummer. Sometimes the Constitution can be incredibly inconvenient, but there you go.
Well, and speaking of the non-delegation doctrine, that's another case we wanted to highlight. And that's the Gundy versus U.S., which in this case had to do with sex offender registry notification. The statute deferred that to the Attorney General to make some decisions as to, for people who had committed crimes prior to the statute, when the requirements would kick in, when these changes would be. And the way the language read was, well, the Attorney General can make those changes when feasible. And this went to a 4-4 decision. This is because before Justice Kavanaugh was seated. But again, it was a Kagan-Gorsuch situation where Justice Kagan wrote the majority opinion, and Gorsuch wrote a 33-page dissent talking about this doctrine of delegation. And Judge Alito agreed with Justice Kagan in the result, but indicated that he believed if there were more votes for reinvigorating the delegation doctrine, he would be for it. So, and I guess I'd ask you, as the liberal, then does that sort of then comports? We're not so different, I guess, is my.
Well, I think there are a lot of conservatives who are conveniently for the non-delegation doctrine because they see it as sort of a stealth way to get government to do less, in a way, because
it's a stealth way.
Well, it is kind of stealthy because they're saying, well, Congress should be more specific on this, knowing full well that that's simply not possible given the nature of society and what we're asking of agencies and laws. And so it basically is a sort of a de facto way of having Congress do less and having less government. And, hey, it's a brilliant strategy, and I salute them for slipping one by a lot of people, But so in a way, though, I understand it if I think it's honestly arrived at, which certainly you are, But then there are people like Ben Sass, who a couple years ago wrote a great stirring editorial, which in the Wall Street Journal, about how Congress is in effect politicizing the courts because they're delegating too much authority, and then courts have to take on this much more political role to decide what these vague things mean. And yeah, I agree with that, but it sure is convenient that he's making that argument. And given who Ben Sass is and what I think of him, but that's a whole other story, so I won't go there.
Well, but we would agree on the basic principle, though, that you sometimes have concerns, as I do, with having a lot of these decisions made by people who are not accountable, not directly accountable, certainly, to the voters. And there's an interest in having that, and that's, I think, the position that I take from the legitimate right, as you would call it. That look, if you don't like a rule, you don't like a result, then you can vote the bums out. But if we are in this administrative state where there's so much deference is, first of all, allowed to be given to, or so much leeway, power is given to these the administrative agencies, and secondly, then so much deference is given to them. I think you would agree with me that telling Congress to do their job is maybe the better republic. We get a better republic out of that, right? Well,
I feel that the court sometimes is very selective in how it uses political doctrine question. What is a political question? Certainly they said that gerrymandering is a political gerrymandering, partisan gerrymandering, is a political question. And this, to me, seems like sort of a political question because, honestly, I would rather not have, say, unelected life-term judges deciding on what a statute means or how it should be interpreted rather than people in these agencies or members of Congress. And so, to me, sometimes the decision is shifted over actually into the judiciary, which I would say is the least accountable of all. And maybe the proper thing for the judiciary to say is just to say, we're going to wash our hands of this, and hey, Congress, do your job, but we're not getting involved because if anything's a political question, this is a political question. And I don't see the conservative court doing that.
No, that could well be, and that's a different perspective, I guess, on the accountability part of it. So, moving forward, looking forward, the new Supreme Court term starts next month. And I've got sort of my favorite cases that I'm watching and looking at. And how about you?
I mentioned my favorite one already. The DACA case. I'll be interested in see where that comes down. But that's the big one I'm watching.
Well, to me, one of the more interesting ones, and again, this goes to the same administrative sort of law delegation issues that we're talking about, is Weyerhaeuser versus U.S. Fish and Wildlife Service, which is about frogs. It's about frogs who live in Mississippi, but maybe they might like to live in Louisiana. And in this case, a landowner in Louisiana, the Weyerhaeuser Company, who has forests that cuts down to make paper, has run afoul of the U.S. Fish and Wildlife Service because they have designated part of this land in Louisiana as habitable for the this type of frog. Now, the frog doesn't live there now; may have lived there sometime in the past. But what would be, I guess, your position? And I understand you're not a lawyer, but to argue just the policy.
That never stops me.
Of arguing that this designation is critical habitat designation, which is what it's called under the Endangered Species Act, ought to be enforced even where the species doesn't live there, and the habitat would actually have to be altered to make it amenable to the frogs.
Well, I guess my first feeling on this is oftentimes it seems like conservatives want to set up a false choice. It's either jobs or frogs, that sort of thing. You want to save the frogs or destroy the economy, that sort of thing. I mean, you don't do that to the extent that a lot of conservatives do, and I appreciate that, Jay. But in this case, I think it's a little more of a fuzzy issue, certainly, and I don't really know how I feel about this. But I guess more generally, I just feel that how this is generally, presented is essentially we have these liberals who don't care about the economy, want to wreck it basically for the sake of the speckle-headed whatever, or the three-toed sloth, or this little frog or something like that. And so I think that oversimplifies the issue in a way that doesn't necessarily, in fact, is designed to stop the debate and not actually get people to think about the issues.
All right, that's a fair response, I think. My other there's two cases are going to probably come up together: Altitude Express versus Zarda, and Boschek versus Clay. And this raises the interesting issue of essentially it's sort of a successor, if you will, to same-sex marriage. And does the Civil Rights Act, which prohibits discrimination on the basis of sex, apply to sexual orientation as well? And this is one of those cases where I will go on the record, and often I say, look, whatever I say doesn't really matter. I'm here often, like as a lawyer, to argue a position, right? To put the argument out there and let people think about it. My personal opinion doesn't much matter. But in this case, my personal opinion would be, listen, I think people ought to have a protection based on, depending on their sexual orientation. They shouldn't be fired because of that. But I would also fight you to death, Mike. Maybe not to the death, but at least...
That'd be a good show. If the video, I don't know.
There'd be some pushing and shoving. To the extent that if we're going to do that, it ought to be Congress that does it. Or better yet, in my view, state legislatures that do it, and not the court reading it into a pre-existing act. See, and if everyone were you, or if every conservative were more like you, I'd be okay with that. But I think you have a lot of good faith. You think far too positively of some of your brethren on the right, I think. And for too many people, Congress should do it, or the state, I agree that confers greater legitimacy on it. Yeah. But in too many cases, that's just an excuse to stonewall to the point where we want to deny these people these rights, and I believe they're fundamental rights, as long as we possibly can for whatever reasons we might have. And so, if all conservatives were like you, I'd totally be for that position, but they aren't, so I'm not. Okay. See, I do what I can. I do what I can to meet you halfway. Any others that would? And my mother was on my list was also the DACA case. But one more that I think is fascinating that I think I want to watch is Kelly versus U.S. And this involves Chris Christie and the Bridgegate controversy. And the weird question that it's going to ask the court is, can a public official essentially be can he be convicted of defrauding the state if he takes an action that he takes for some ulterior motive? And in this example, it's Chris Christie, the administration, not necessarily him.
He wasn't involved in any way. No.
Yes, Kelly, who was the Department of Transportation person, shut down a highway ostensibly because while it needed repairs, needed shut down. Then other facts of service that suggested it might have been political payback to a certain municipality. But I think that's a fascinating question of to what extent do we get into motives of political actors? If the action is legitimate, if they're empowered to do that, does their motive matter? And we could actually bring this into it. I didn't want to bring the whole big, set off the bomb here, but to the Comey.
And you were going.
Yeah, I mean, it's sort of so often we get talked, and this isn't. We're trying to focus more on judicial questions here, but it's the same thing. If you have the authority to fire someone and take an action, does it matter if you do it for a bad reason or maybe not the reason you say?
Yeah, I mean, and you and I think, are going to largely agree on this. I get real uncomfortable when the court starts, splunking around in there trying to figure out motives and so forth. And so, I think that's, if you're an elected official, then, in some way you're accountable to the people, then I don't want the courts really kind of getting into motives unless it's a really egregious case, I think. So to me, that I get a little uncomfortable with that, with the courts having that much power to decide on motives.
So if we're talking now, and again, this is always the fun part of it also, predictions of these cases we've talked about. Are you willing to go on the record on any?
Oh, I don't have a clue, but I really don't know what's going to happen. But I'd be happy to hold you to some predictions.
No, I will say I think Kelly to U.S. I think the court will find by at least with at least 6 or 7 members saying no, we don't want to. That's not something the courts ought to delve into, and I think you can make distinctions sometimes if the motive is a illegal motive, for example, if it was to obstruct justice, in that case, then yes, that might be a different case as opposed to I'm doing this because it really needs to be done, or it's also just politically expedient and sticks it to one of my political enemies. Well, other than that, you know what? I mean, this is the usual wrap-up for the show, but what we're going to do here, which is really the fun part, because we can engage you now, because it's been a weird presentation. Mike and I sort of talking to each other, and
there you are.
Out there. Yeah, there you are. We'd love to hear from you on questions regarding anything we talked about, other political issues we talked about, or just the bigger meta picture of what we're trying to do in terms of...
what are you guys trying to do?
Yeah, the civil...
Why are you here?
Again, bring these kind of discussions out into the world, and hopefully, or you were pretty animated though today, more so than usual. But
put me in front of the crowd.
Yeah, exactly, it's the segment of the crowd.
I spent my life trying to keep your bored 19-year-olds awake, so you really kind of have to ramp it up for the most part,
But just the idea of. What we always set out to do is not necessarily to win an argument, but to have a discussion.
Sure, absolutely.
So, and hopefully that's what we're doing today. But we want to hear your discussions, your questions on any of these things, or just the lucrative world of podcasting and how you can get in on it and anything like that. Anyone? Yes?
The gerrymandering issue, hasn't that created much of the divisiveness and won't continue on? The court won't address that issue?
I think that's an awesome question. I would say this is something we hit on a fair amount.
Gerrymandering
is gerrymandering, with the idea that because I think it's a question of technology now. We have such technology that we didn't have 20, 30, 40 years ago. In order to get down to almost like a household level, we want this household in the district, this one out. That they can draw these districts so precise, and that leads to a race to either the right or the left. Right? You want to be sort of the most right-wing candidate in certain districts, the most left-wing in others, and that leads to the greater divisiveness that we see in Congress and to I think a lesser extent in state legislatures. But my position is typically there are other ways to fix it rather than the court intervention. For example, Ohio is one of the states that has taken some some action in terms of giving a bipartisan commission, withdrawing the districts, giving more voice there. Other states have done things by a referendum, again, either approving plans or approving some other oversight board to do that. And my sense is the founders understood that districting was going to be political no matter what. There's no way you can get around that. And I think, in my view, I think that the court did the right thing in saying this is a political question, and we would defer back to the other remedies that states or the districts might have. And the other thing I point out is of course, that just because districts are drawn and it seems to be you have a certain number of people. That map holds up for a while. There's change over time, right? I mean, states flip. Even without redistricting. And also the people who draw the districts, the state officials, depending on what state you're in and how it works. Again, you can flip a map based on that. So I agree absolutely. I think that gerrymandering is a problem. I differ with what the solution is, and I'm hesitant to have courts in the business of drawing districts, because the next thing you get then is also challenges to every single map is always going to have challenges, and you're going to be not only waging an election campaign, but then litigation over the districts.
I disagree. I feel that the court's business sure isn't to write laws, but the court's business is to address violations of the Constitution. And when gerrymandering becomes so egregious that it's a constitutional violation, I feel the court's not doing its job by kicking it back and saying, "Well, I hope someone does something about it." I don't know. I sort of agree with former Justice Kennedy on this, who basically said, I think this could be an issue, but we don't really have a standard. And he was right for a long time. And, to pat my discipline on the back, a number of political scientists and other social scientists came up with what I think was a very good and workable standard. And obviously a majority of the justices on the court didn't agree that was...
And that is, you can walk people through that, because that is...
That's a lot of math.
It's too complicated for me, because it's a lot of math, which is exactly...
But the point is, and you can argue certainly, well, is this standard the right standard? But the court didn't even do as much as that. They just basically said, "Oh, can't deal with that sort of thing." And I think that's the court just not doing its job, as opposed to just not dealing with a legitimate political question. So to me, I think it's better if states deal with this, certainly. My preferred method, in terms of legitimacy. But when there is it raises to the level of a constitutional violation, like you said, with the technology in that, and I really think that the court missed an opportunity and really failed to do its duty in this case.
Well, and my response, as typical, and as you would expect this, would be which part of the Constitution do you find that right to vote for in the district of your choice, I suppose, or have the district mirror to vote in the district that mirrors your political aspirations.
I mean, that's the same conservative argument. Where do you find gay rights in the Constitution? It doesn't say anything about sex.
That's why I'm for statutorily.
I think it's a bogus argument.
So, okay, who else? Any other questions? Yes.
Don't you think that as our nation is evolving, what used to be deemed local issues or state issues or concerns are now having national implications?
Yes.
Certainly in many areas of our lives, this is the case. Education, for example, used to always be that the states decide on public education. That's no longer the case. And it's now with gun control, the same thing. And so many issues, and I think we're all upset and concerned about this. Certainly, I would think liberals ought to be, as well as those who are not so liberal. That the solutions we're looking to Washington more and more and more, and I think that's a almost social necessity. Yeah. But at the same time, it probably is going to have some albatrossian
Yeah.
consequences.
I think
I refer to you on this
Yeah.
because you probably have more data and numbers on how this changed. But I think there is definitely a switch that now everything we see is sort of a federal solution first. And it could be just because of the media that we're now much more tied together as a country. And there's sort of, for if you're an interest group, it's sort of one-stop shopping. The idea, if you can sell it to Congress, that saves you the trouble of selling it to 50 legislatures.
But our state governments, with gun control, are saying cities can't do it. Oh, no, you're not allowed to have any local legislation. It has to be done through the states.
My comment is I think people on the left have focused too much on the national level, and kind of under the radar, a lot of state level politics have become dominated by conservatives, and they've built up that grassroots, and they've won a lot of those battles. And so now liberals are playing catch up kind of across the board in a lot of state legislatures, and they're making up some ground, but we lost a lot of ground in the last decade and a half, and we've got a lot of heavy work ahead of us.
To your question, I'd also put in a plug for Judge Sutton's book, if you haven't read it, 51 Imperfect Solutions, which talks less about necessarily state legislative actions, but the idea of people could bring change in state courts. And doing this based on state constitutions, sort of one at a time, and you get more of this laboratories of democracy effect, where you don't have a one size fits all, because it's not going to in a country of this size and diversity. And second, to the extent some things could be scaled up to work, you get the trial run. But yeah, Judge Sutton has written really eloquently on that topic.
One final point on that, though of course it's a lot easier for state governments to be overrun by big money and interest groups, oftentimes who are much more conservatively oriented. And so a lot of times, again, I feel this is part of a sort of a stealth agenda, if you will, because it's a lot easier to exert that influence on largely unprofessionalized state legislatures in many states, and kind of to have their way with these legislative bodies.
I wish I was half as sneaky as you think I am.
No, not you. See, you're like I said. If more conservatives were like you, I'd sleep better at night, Jay. But they're not, and I don't.
Oh, okay. What else? Who else we got? Other questions?
I think
comments,
that's
thoughts.
about
Deneen.
it.
Oh, Deneen, we're out of time. Oh, okay. One more. Anyone? Well, thank you for sitting through this. Like I said, this is an experiment. Our first time actually trying to do a podcast from an audience and see how it plays. But hopefully, what we're able to show is this is the kind of thing we're trying to do, where we have a conversation and hopefully bring some more light than just heat.
We forgot the most important thing. If you want to hear more, you can find us wherever you get your podcast. If you get podcasts, and we're the Politics Guys, or just go to politicsguys.com. We also have, as some of you know, an incredibly lively Facebook group, facebook.com/politicsguys page, where all kinds of interesting things happen all the time, especially with some of our attorney members who give me all kinds of flack, and I love it. Anyway, thanks very much. We really appreciate it. That's it for this episode. Thanks for listening. We hope you like what you heard. Listener support is what keeps the show going, and we truly appreciate it. When you become a monthly sustaining supporter of the show on Patreon, you don't just get our gratitude, you get a supporters exclusive bonus episode each and every week. Also, supporters at various levels can get additional bonuses like Politics Guys gear and access to a special supporters only Facebook group. To learn more about all this stuff, go to patreon.com/politicsguys, or you can visit our website, politicsguys.com/support. Subscribing to the show also really helps, as does sharing episodes. Word of mouth is, of course, the best advertising, and we really would appreciate it if you tell folks about the show. Leaving reviews and ratings on whatever podcast app you use is also greatly appreciated. If you want to get in touch with us, you can do that at mail@politicsguys.com. There's also our Facebook page where you can message us, and where we're posting things throughout the week. It's facebook.com/politicsguys page. Finally, we're on Twitter @politicsguys. The executive producers of the Politics Guys are Bruce Johnson, Wilma Moreno, Benji Fishman, and Andra Masker. Today's show was produced by Michael Baranowski. We'll be back with a new show on Saturday. We hope you'll join us.